This meeting is being recorded.
Hello, and thank you for joining us for our second loans, also known as zombie loans, our zombie second mortgages and HELOCs homeowner help workshop. Today, we'll be covering second loans and HELOCs and what happens when they threaten foreclosure. And my name is Connie Dertarosian. I'm with Homeownership OC. And we are a nonprofit HUD-approved housing counseling agency, also known as OC HOPC or OC HOC. And our mission is to promote and preserve the dream of homeownership. And we do that through outreach, education, counseling, and financing. We were started back in 2007, and we've done over 70 housing events and workshops, educated over 18,000 individuals on homeownership, credit, foreclosure prevention, avoiding real estate scams. And our website is homeownershipoc.org. You can find all kinds of great information and also some educational workshops that we have online. So today we have a special guest presenter. We have Pat Pinto, and she was formerly on our board of directors, but she has over 20 years experience in the nonprofit housing, counseling, and legal services area. And she's an attorney who specializes in real estate fraud, title issues, and she educates the housing industry on these issues. So Pat, did you want to introduce yourself? And I can hand it off over to you.
Great. Hi, everyone. Thanks for attending today. Go ahead and just change the slide. So today we're going to talk about second loans because they seem to be popping up in our community. So let's talk about some of these second loans that have turned into zombie mortgages. What are they? Well, they're typically a mortgage that was taken out perhaps decades ago, and they've just been sitting around, and the homeowner thought they were gone. Well, why would they think their mortgage was gone? Well, maybe they filed bankruptcy and they thought they discharged it in bankruptcy. Or maybe they spoke to their lender and the lender said, you know what, we're going to charge this off. You don't have to pay it off any longer. And so they've gone forward now thinking that the loan was gone. Well, maybe the loan is gone, but the lien is still there. Now, these second mortgages are called zombie mortgages because the borrowers thought the loans were gone, but now they're coming back to life. There's a nightmare trend that is going on, that these zombie second mortgages are rising up from the past to haunt these unsuspecting homeowners, and by starting foreclosure proceedings and threatening the owner's ability to stay in their home. And it's usually a collection agency that is starting these foreclosure proceedings. Next. So today's topics. Today we're going to talk about bank write-offs of these second loans. Again, you have to remember, it does not always remove the lien. And for those people who file bankruptcy, if you go all the way through bankruptcy and get a discharge, it does not always remove the lien. Next. So we've had several homeowners come to us with questions about their second loans. Again, these second loans were taken out over a decade ago, maybe even 2 decades ago, and the borrowers thought the loans were just dead and gone. On some of these second loans, the lender had told the borrower, okay, we've written this off because your house is underwater and you're really no longer secured. And so they wrote it off and said you don't have to make any more payments. And again, some others, homeowners went through bankruptcy and they thought the loan was discharged. Now the loan was gone, but the lien is still there. Next slide. So what is a loan versus a lien? Now a loan is where you receive money from a person or an institution and you promise to pay it back. A lien is an interest in property to secure payment of a loan or performance of an obligation. So when a loan is made by a lender, it records paperwork, the lien, against the property, which is released when the loan is paid off. So if you file bankruptcy, the loan's not paid off. If the bank says to you, oh, we're going to charge this off, you don't have to pay us back, you haven't paid them back. So the lien is still there. And so that's why so many homeowners are confused. They didn't understand this. And a lot of homeowners thought that their mortgage or their deed of trust was gone, but it's not. It's still there attached to their property. Next slide. So here's an example of a lien. You buy a house and the lender loans you $100,000. Now you sign a note, which is a promise to pay, with the lender for $100,000. You also sign a mortgage, which is a lien that the lender records against the property. Now I'm going to use the word mortgage tonight, but in California, we have what you call a deed of trust instead of a mortgage. Some states have mortgages, some states have deeds of trust. But here's the difference between the two. A mortgage has two parties, a lender and a borrower. But a deed of trust here in California has three parties. There's the lender, the borrower, and the trustee. The trustee has the power to foreclose on your property. So when you sign a deed of trust in California, you're signing your name and you're saying, okay, I promise to pay this money. And if I don't, hey, trustee, you have the power to foreclose on my home. You don't have to go to court because we are considered a non-judicial foreclosure state. So he just goes down to the recorder and he records a notice of default if you don't pay. Now in another state, let's say Florida, that's a judicial state. They have mortgages. So if you don't pay your mortgage there, they have to file a lawsuit against you to foreclose out your home. But here in California, you don't. It's quicker, it's faster, of course, and there's no lawsuit. So if you have a deed of trust and you don't pay, you're not going to get in, you're not going to get served with any paperwork from the courthouse. You're going to be served with that notice of default. But you must pay off that lien in order to remove it from your property. Now, another way to remove the lien is for the lender to foreclose. When he forecloses out the property, that will extinguish the lien. Next slide. And when I say lien, let me just say one more thing. There are a lot of liens out there. Now, a mortgage is a lien, but there's also other types of liens. There are tax liens. Someone can sue you and get a judgment lien. So there are many types of liens, and they can all be foreclosed upon. But tonight, we're going to focus in on these second mortgages or junior liens. And so the second mortgage is a loan that you take out using your house as collateral. Well, you still have another loan secured by your house. So you have your first lien, which is your purchase money mortgage. And then maybe you wanted a little more money. So you took out a second lien or maybe a HELOC, and that's in second position. Now, home equity loans and home equity lines of credits, HELOCs, they're common examples of second mortgages. Next. So what is a HELOC definition? Well, it's a line of credit where the lender agrees to loan a maximum amount with an agreed upon term. Now, the collateral is usually the borrower's equity in their home. It's usually a second mortgage. And the lender typically does not advance the entire sum of closing. It advances, and the advances are obtained through credit cards, debit cards, or checks, and the interest rate is variable. So for instance, you can get a HELOC and it can be a 30-year term. The first 10 years is the period of time where you can be borrowing money on it. And then you spend the next 20 years paying it off. And to pay it off, to use it, they give you credit cards, debit cards, or you can use checks. Most people just usually use the credit card now. Next. So what are the issues we have with HELOCs? Well, our big issues right now are the lender write-offs, where people thought that their loan was gone because they got a letter saying it was written off, but it was actually just sold to a collection agency. And we have the people who filed bankruptcy. They thought the loan was gone, but no, it's still there. Actually, the loan is gone, but the lien is still there. Now, many homeowners have taken out these HELOCs. Again, they're typically secured by the home. It's recorded against a secure property. And, right prior to the recent recession that we had, and right prior to 2007, 2008, 2009, some of these homeowners experienced hardships and they were unable to repay the second loan. Next. So HELOCs, they're usually paid off by the borrower. Sometimes they'll sell their home, and when they sell their home, the HELOC is seen in the title report and it's paid off. Or if you refinance the property, your lender is going to see in your chain of title, they're going to see that second lien and it'll be paid off. And so even though the homeowner may think that the lien is gone because either they filed bankruptcy or the bank told them it was charged off, that lien is still there, and your lenders or your sellers, whenever they get the title report, they are going to see that lien is still there recorded against your property. Now, HELOCs, they can either be paid off by the borrower, they can be discharged in bankruptcy, or they can be written off by the lender. Excuse me. So, like I said, sometimes homeowners, they were just unable to pay off the HELOC. And so many homeowners, they went ahead and filed bankruptcy and they had the loan discharged. And they thought they no longer had to pay on the loan. But a discharge does not mean that the lien was extinguished in bankruptcy. In bankruptcy, to get rid of a lien, you have to go through a process of stripping the lien. And many people didn't know that, and they just filed, regular Chapter 7 bankruptcy, and the lien was not stripped or removed from the property, so that lien is still sitting there. And again, many lenders wrote off that second loan, but they didn't remove the lien. They just turned around and sold it to a collection agency. So unfortunately, the lien was not always removed when the HELOC was written off or discharged in bankruptcy. Next. So let's talk about these lender write-offs. Now, I kind of use the words write-off and charge-off interchangeably. But I saw recently that some collection attorney, I saw him online talking, and he says, here's the difference that he sees it. A lender, typically, they'll use the word charge-off when they say, okay, we're going to charge this off, you don't have to pay it back. But if you go through bankruptcy and you actually get it stripped, and by that I mean you get an order stripping it, and then you give it to the lender and say this has to be removed, then the lender will refer to it as a write-off. But again, mostly it's just used interchangeably. Next slide. So again, before 2007, HELOCs were just routinely obtained by borrowers. Everyone and their neighbor had one. Everyone was remodeling their kitchen because we had equity at the time, and putting in a pool. And then after the recession hit us in 2007, these defaults started to increase exponentially when people discovered that they couldn't make their house payment. They could barely make the first, let alone the second. Because remember, the homeowners were underwater. Remember, our property values went down about 50%. So if you had a house that had value of $400,000, by the time 2007, 2008 started hitting, your house went down in value to about $200,000. Now, lenders would often write off or charge off the loan instead of foreclosing because there was no equity in the property. Lenders don't like to foreclose. Foreclose is expensive. They have to pay a foreclosing attorney. They got to pay the trustee to do it. There's court fees. There's recording fees. They don't like to do it. So sometimes banks will just write it off instead of foreclosing. It's just cheaper for them. And so that's what happened to a lot of HELOCs in our recent recession. Next. So charging off or writing off refers to the mechanism where the banks, credit unions, or other creditors determine the debt it's unlikely to be repaid by the borrower and therefore just can't be collected. So as a result, the loan is charged off and it's deemed a loss of principal and interest. However, a charged off debt is not forgiven and may still be pursued for debt recovery. Next. So lender write-offs. First, we have lender write-off issues. Then we have the HELOC written off, but the lien is not released. And then we have the HELOC written off, lien not released, and then the loan sold to a collection agency. And see, of course, the borrower doesn't know that your lender is selling your loan off to some collection agency. And if you know anything about collection agencies, first of all, they buy it cents on the dollar, and then they sit on it for years, and they wait for you to either sell or refinance. And then they raise their ugly head and say, hey, pay me this amount. And of course, the homeowner's, shocked and surprised because they thought the mortgage was gone. Well, it's not gone. It's just been kind of there, laying in wait, waiting for the homeowner to sell or refi. Next slide. Now, lenders are allowed a deduction for the write-off, but they're also allowed to pursue the debt and generate recovery. That means they can sell it to a collection agency. So lenders can sell written off loans as non-performing debt to third-party collection agencies. And when they do that, they're not going to release the lien when it's written off, because what the collection agency is really buying is that lien. Because in California, that lien is recorded against your property forever. And it just keeps going up in value over the years because interest keeps going on. So collection agencies will buy these loans and just sit. Maybe they'll run the property every 6 months to see if you've sold it or if you've refinanced, just in case they were not contacted. But typically, if you want to refinance or sell your house, you open escrow, and then escrow is going to contact every single lien holder that has a recorded document against your property. And that's when the collection agency, or actually the original lender, will be contacted. And they will probably say, oh, they owe X amount of dollars, or, oh, we sold it to XYZ collection agency, contact them. Next slide. So here we have a situation where the lender sent paperwork to a borrower. The lender went ahead and generated the IRS 1099-C cancellation of debt, which shows the amount of canceled debt and the date of the cancellation. And that this is a document they're going to send to their borrower. The loss is reported by the borrower in the Schedule D of their tax return. And so I see that quite often, but the lender does not explain to the borrower that their loan has been sold to a collection agency. So all you get in the mail is this 1099-C from the lender, and you say, oh, look, my debt's been canceled. I don't owe any money. Isn't this great? But what they don't say is, oh, by the way, we just sold this to a collection agency and your lien is still attached to your property. And one day they'll be knocking on your door to collect on it. Next. So here's a sample of this 1099-C. Next. And here it is again. This is just the whole long form, so you can see what it looks like, what you would get in the mail. You can't see it very well, but there is a number in there. I think it was like, I don't know, 89,000 or something. And that's on this document, on this loan. That's how much the bank wrote it off. Now, if you are the borrower, you got to pay taxes on that. You have to file your taxes, and you have to show that. And that's considered income to you when you don't have to pay that loan back. So the borrower has to pay taxes on that. Now, written off loans are very similar to loans discharged to bankruptcy. The borrower is not personally responsible for the loan, but the recorded lien stays attached to the property. Many borrowers are unaware that the property is still encumbered by the lien, although written off by the lender. And many borrowers mistakenly assume that their liability for payment is forever released, but that is not the case. The lien is still there, and you are going to have to probably pay it off one day. Now, when a lender writes off or charges off a secured loan, the deed of trust, as we've said many times, is not automatically released or recorded. Now, sometimes it is. There are some unusual cases, excuse me, that I've seen over the years where the lender has released the lien, but it's like less than 1%. Usually they don't. The deed of trust remains of record until it's released. The borrower usually discovers the lien is still attached to their property when they go to sell or refinance. Now, if the borrower is trying to sell or refinance the property, escrow, like I said, is going to contact the lender for the payoff when they see that lien. They're going to contact him and say, oh, can we have a release on this because the homeowner said it's paid off? And that's when the lender says, no, it wasn't paid off, and we sold it to a collection agency in it's XYZ collection agency, and you should contact them for a payoff amount. Next. So when selling or refinancing, the lender may claim money is owed. You ask the lender, well, why wasn't it released? Go ahead and release it for me. You told me I didn't have to pay. And the lender's going to say, no, we sold it to a collection agency because they have the right to do that. So if that loan is sold, you ask for the name of the third-party collection agency. Because remember, that collection agency probably will not contact you over the years. They're just sitting there waiting. So if the loan is sold, you're going to need to negotiate with the collection agency to obtain the release of the lien. Now, our property values are pretty high right now. So if this is happening to you right now, you probably have equity, and you probably have enough equity to pay off that deed of trust. So the collection agency is probably going to demand that you pay it in full in order to give you a release of that lien. Next. Excuse me. Most likely the collection agency has been monitoring the property, just waiting for you to list the property for sale. Now, you can offer to pay the collection agency. You can offer them a small amount of money if you want, and see if they'll take it. But like I said, if you have a lot of equity in your property, they're probably going to want every penny right now. Now, these collection agencies, they're really not nice people. They're pretty aggressive. You know, the kind of people who work at collection agencies, they don't want to be your friend. They just want their money. And so they're not likely to negotiate if you have equity in your property. Next. So once the property is up for sale, it's going to be more difficult to negotiate with this collection agency. So if a collection agency sees you have equity in your property, it may demand the full amount to record the release. Now, if you don't have a lot of equity in your property right now, and you think that your lien is still there, now would be a good time to negotiate with a collection agency, because you wouldn't have to pay them 100% probably. So let's talk about some bankruptcy issues. Here we go. There are a couple different types of chapters in bankruptcy. There's the Chapter 7 liquidation. That's typically a no asset. There's chapters 11 and 13. Those are reorganizations. And then there's a Chapter 20, they call it. That's a term used when someone usually files a Chapter 7 and then files a 13. So then they call it a 20. Next. So here are just some definitions. The bankruptcy petition. So these are just the pleadings. These are court forms that you fill out, and then you file them. The individual seeking the bankruptcy relief will file them. You know, it's court forms, and it's, you know, all the information needed, name, address, and, you know, a list of your creditors. Who's the debtor? That's the person, couple, or entity who filed for bankruptcy. Who's the co-debtor? That's a person who's obligated or whose rights may be affected under the terms of the debt. But this is someone who did not file the bankruptcy petition. So it's maybe someone that maybe you own a house with someone, and so they may be a co-debtor, but they're not filing bankruptcy with you. You are. Now, the debtor's estate or bankruptcy estate, pursuant to Section 541 of the Bankruptcy Code, upon the filing of the voluntary petition, an estate is created, and it's comprised of all legal or equitable interest of the debtor in the property as of the date of filing, plus interest by devisee, inheritance, or property settlement vested in the debtor within the next 180 days. The estate holds the assets of the debtor for the benefit of the creditors, unless the assets are liquidated or distributed or abandoned and given back to the debtor if they seem to be valueless to the estate. Now, property of the estate may not be conveyed or encumbered without an order from the bankruptcy court. And by that, I mean, if you file bankruptcy and you own a house, you cannot take out a loan, you cannot deed it away to someone, you can't do any of those things to your property once you filed bankruptcy. An automatic stay Immediately upon the filing of a bankruptcy petition with the court, an automatic stay is imposed that prevents all creditor actions against the debtor. Even if the creditor doesn't know about the bankruptcy, as long as the debtor did not intentionally avoid notice to the creditor for the purpose of preventing the creditor from participating in the bankruptcy case. Next. Liability. For purposes of bankruptcies, a debtor's liabilities include any debt or financial obligation of the debtor, and assets. For purposes of bankruptcy, a debtor's assets include any property, both tangible and intangible, that the debtor owns or may claim an interest in. Next. What is a claim? A claim is defined by the bankruptcy code as a right to payment or a right to an equitable relief for a failure of performance. So creditors file claims. If you owe someone money, they're a creditor, they will file a claim into your bankruptcy and ask for that money to be repaid. And what is unsecured debt? That's any debt that is not secured by an asset of the debtor. So like maybe a personal loan, maybe a loan from your mother or somebody, that's unsecured. Credit cards are typically unsecured, but a mortgage, those are typically secured. Next. Now, secured debt. Any debt that is secured by an asset of the debtor, that's notes, secured by security deeds, maybe automobile financing loans, things like that. And what is the discharge? That's a permanent court order that releases the debtor from personal liability for certain specified types of debts, thereby releasing the debtor from any legal obligation to pay any discharged debts. Next. Although your personal obligation on a secured debt may be wiped out in bankruptcy, the lien survives and stays attached to the property. If it's a secured debt, that lien is going to stay. Bankruptcy works well to wipe out many types of debt. However, if a lender has a lien attached to the obligation, meaning that the lender can take certain property if the borrower fails to pay, things can get tricky. Remember, the loan may be wiped out, but the lien remains. Next. A lien or security interest is wholly unsecured if the equity in your property does not cover any of the lien amount. So for example, let's say your home is worth $500,000, but your first mortgage is for $550,000, and your second mortgage is for $50,000. Your first mortgage is greater than the equity in your property. There's no equity left to cover your second mortgage. Your second mortgage is completely underwater. If a lender were to foreclose, the first mortgage holder would get the first $500,000, and the second mortgage holder would get nothing. So no lender is going to foreclose in that situation. And remember, foreclosures cost a lot of money. So it's just cheaper for the lender to write it off or charge it off. Next. Lien stripping. Now, lien stripping is the process of eliminating junior liens during a Chapter 13 bankruptcy. It allows a bankruptcy filer who's upside down or underwater on his property to wipe out liens on a property. Now, you can't strip a lien in a Chapter 7 bankruptcy, and unfortunately, 70% of the bankruptcies that are filed are Chapter 7. There's no lien stripping in those. Only the guy who files a Chapter 13 can try to strip a lien away from his property. Sorry, coughing. Now, what is lien stripping the second mortgage? Because your second mortgage is a second debt, the lender has the right to foreclose on your property if you miss your payments. We all know that. During lien stripping, the court directs the lender to remove a lien from your property. So what you have to do is you have to file a motion. You have to get an order. The judge signs the order, and then the order is sent to the lender to remove the lien, and they will remove the lien by recording a release. And then your chain of title will show that the lien is removed. But again, there's no lien stripping in a Chapter 7 bankruptcy. Next. Sorry. Again, a Chapter 7 is the most common bankruptcy. Lien stripping is not allowed. Only in Chapter 13 is the lien stripping allowed. Again, this is many steps. And, during the recession, I don't know if you remember this, but be driving down the freeway, you'd get off the freeway, and there'd be signs all over. They'd say, bankruptcy, $1,500, bankruptcy, $1,000. And, just these stupid signs along the side of the road. Well, those were bankruptcy attorneys, I guess, doing the bankruptcies for a flat fee. But, that flat fee did not typically include lien stripping. That's extra. So you have to file a motion. The judge has to see it and agree to it and sign it. And then you send the motion to the lender. Many extra steps, a lot more money that you have to pay. So not a lot of loans were stripped from the land when the people filed bankruptcy. But I can tell you, people don't understand that. On more than one occasion, I've had a homeowner say to me, oh, I don't worry about that because I filed bankruptcy. The lien is gone. Well, the lien is not gone unless you had it stripped in the bankruptcy. If that debtor did not pay and file the motion and obtain the order to strip the lien, that lien stays attached to the property. Next page. So, conclusion. During the recession, many homeowners had their HELOCs written off by their lender. Many homeowners filed bankruptcy to stop paying on their second loan. But these two processes did not remove the lien from the property. And many homeowners were not aware the lien remained against the premises. And now they must pay money to remove this zombie lien. Next. So if your second loan was written off or discharged in bankruptcy, but this, second lien or zombie lien, as we can call it, if it's still there, you have a few options. Number one, pay the mortgage in full. Go ahead and pay it off to the collection agency, but that's difficult to do. You can let the second mortgage foreclose. Well, that's not an ideal situation. You don't want to lose your home. Or you can contact the party that now owns the lien and try to negotiate for its removal. They may agree to let you, pay just a percentage of the debt's face value if you offer, a lump sum. But if you've got the full equity there, they probably will not do that. You can work with the housing counselors at Homeowner OC to negotiate a workout for you. Or you could sell the home, take the money, and run. So you got a couple options, but not all of them are great. I think that's it today. And thanks so much. And back to you, Connie.
Okay, thank you, Pat. That was excellent information. So I'm sure you all have a couple of questions you want to ask Pat, and we'll be happy to answer some questions for you. That was some really good information. I even learned some stuff, and hopefully you guys learned some information as well. So go ahead and put your questions in the chat box or in the questions box, and we'll go ahead and answer them. And let's see if we have any questions so far. One question is, what is the difference between a HELOC and a second loan?
Oh, a second loan is just a regular loan, but it's just, the regular loan, you ask for the money, they give you the money, like all at once. And you have typically you have a not an adjustable interest rate. You have, one that and you get the money handed to you. You don't get it by credit card or by check. Where the HELOC, you get the money over time. You can take it as you want it. Take some, take none. And usually there's a draw period of the first 10 years of a HELOC. Like I've seen them like 20 years or 30-year ones.
Okay.
Where a second loan is just a regular loan.
And a lot of the California folks didn't have down payment. So what they did is they got a first loan for 80%. They got a second loan for 20%, which was the down payment, right? And so they have a first and a second, and that would just be a second loan.
Right. That's not the HELOC.
Right. HELOC, something different. typically a line of credit, right?
Right. It's a line of credit, and usually people were getting it to do home improvements.
Right. Okay, let's see. Can a homeowner request a servicer on a second loan? How they came up with all of the fees? Like they add up all these additional fees on the second loan.
Sure, you can ask for that, and they should give it to you. They should, put it right there in front of you so you know what you're paying. Otherwise, they can make up any number. You want to make sure that they got to the number,
So you ask for a breakdown of the fees or a loan payoff or something, because typically
principal,
these people
interest.
haven't paid for 10 years. And so now they're going to charge them 10 years of interest. And
Right.
I did see one client who had a lien. It was originally 260 and it went up to $660,000 after 15 years or something like that.
I was going to say over a decade. Yeah.
Yes, it was a long time. So
yeah.
Okay, very good.
Well, in California, the interest rate for a loan, for a lien that was, say, a judgment lien, is 10%. So if someone gets a judgment against you and they record it against your property, let's say it's $10,000, in 10 years, it would be valued at $20,000 because it actually doubles every 10 years at 10%.
Oh my goodness.
Yeah.
Okay, here's another question. How are you able to strip the lien if you have equity and you don't want to sell your house?
Yeah, you're not able to if you have equity. You have to be underwater.
You can only do it if you're underwater. So you can't strip the lien. You're going to have to negotiate with them.
Yes.
And is there a statute of limitations on when the servicer can collect the money?
No, we don't have that in California on a mortgage. There's no statute of limitations on a mortgage. I think some states do, but we don't have that. I regularly see 40-year-old deeds of trust that are still recorded, and people owe money on them for whatever reason.
And one more question. If I file bankruptcy, can I negotiate with the second lien holder during bankruptcy?
That's something you should need to talk to your bankruptcy attorney about. That would be their job.
Okay. And do bankruptcy attorneys usually talk to you about the lien stripping, or they just file bankruptcy and deal with your stuff? And that's not
I don't know. I'm not a bankruptcy attorney. I would think they would be explaining the process to them, but I'm over the years I've talked to so many people who thought their lien was gone and it wasn't, so I don't know.
Yeah. Well, I can say majority of the clients that we're working with that have second loans don't know that loan is still a lien on their property.
Well, they probably filed a Chapter 7 and there's no lien stripping in the Chapter 7.
Yeah. Yeah, no, you're right. That's right. All right. Any last questions? Go ahead and submit them. Let's see. If I have a sale of the loan to the collection company, if they have a sale, if they sell the loan to the collection company, you still have to be underwater to get it stripped?
If they sold it to a collection, if they sold it to a collection agency, say 10 years ago, to get it stripped in bankruptcy, you'd have to speak to your bankruptcy attorney. But if you have equity, I don't see a judge stripping the lien, because then you can still pay it.
Okay. And they can sell it at any time, right? They can charge it off. They can sell it at any time they want.
A homeowner can sell their house at any time they want. Yes.
No, I meant the lender. The lender can charge off the loan or.
Yes. Yes. There's a collection agency out and about right now, real aggressive company called SLS. And they bought all the loans from Countrywide and from
Bank of America.
Bank of America, right.
Yeah.
And that was, before, right as the recession hit. Remember when Countrywide went down? And they're just collecting now. So they're collecting on loans from 2006. But nobody's underwater right now. So that's why they're going forward, trying to collect, because everyone's got equity and we'll have to pay them in full. So if the homeowner right now thinks they can file bankruptcy. They can file bankruptcy if they have other debts, but they're not probably going to get that lien stripped, because I think you have to be underwater. If you've got equity, you can pay it and you owe it.
Right. Now, what if the servicer can't prove that he can collect what they claim I owed?
Well, that's an interesting question. You know, there are attorneys out there who do this collection, and they can give you all sorts of information about that. I think you can even just call them and talk to them over the phone and ask questions like that. So that might be the route that you want to take, because they do have to have some paperwork. They have to show that they own that lien somehow. And, you know, some of those lenders, I mean, some of those collection agencies don't have that information, and they do have to have the paperwork.
Mm-hmm. Okay.
So-
No, this is really good information. So if you do have additional questions, we're always here to help you. What I have seen a lot of these folks who have second loans, they'll offer you modification, which is 30% down and then some payments for a period of time. So let's say it's 100,000, they'll ask for $30,000 upfront, and then they'll want a payment of $600-700 a month. And so for the most part, clients can't do that. So we have been successful in certain circumstances where we've been able to get the amount down. Maybe it's $10,000 upfront and then a monthly fee. So you can negotiate with them, but they are pretty ruthless. Like Pat said, they're pretty ruthless, and they've done the numbers, and they know that they have that you have equity in the property, and that if they foreclose, they're going to get paid in full, most likely, which includes all of their interest and fees and all of that good stuff.
Foreclosure fees as well. They recover those as well.
Right. And do they have to prove that I owe this amount with my original signature on the documents of the loan and all of that?
You know, I don't practice that area of law. I don't know, but I
It's
do know
probably
paperwork.
a question for the attorneys if you're interested in talking with one of those collection attorneys, right? That can deal with it.
Mm-hmm.
All righty. Well, thank you so much, Pat. I appreciate you taking the time. I know you were a little under the weather, so I appreciate you hanging in there with us.
Sorry about all the coughing, folks.
Hey, at least she wasn't in person, so she's not spreading her germs.
Yeah.
So if you do have additional questions, you can always reach out to us. You can go to our website. If you haven't filled out an intake form, fill out our intake form and we can help you with that. Or if you just want to give us a call at 204-2314, we can answer your questions, or shoot us an email. So thank you again, Pat. And we are happy to bring this information to you, and hopefully you all learned a little something tonight. So thanks for your great questions. And Pat, thank you again for the presentation.
You're welcome, and good night.
All right. Thank you.